Greetings everyone, welcome to this session of Indian Polity. Dear students, in today's session we are going to discuss about the recent verdict of Supreme Court about Articles 200 and 201. Topics like federalism, central state relations, president and governors are the favorite topics of UPSC, and there is high chance that in prelims and mains 2026 questions may be asked from this topic. Now let's see what are we going to discuss. So first we will discuss the context. What is the context? Then we will discuss the key provisions of Articles 200 and 201. Apart from that, we will also discuss 14 questions which were referred by the President of India to the Supreme Court under Article 143. Now, let's begin. So first we will discuss what is the context. Context is very important. Whenever you read any news, any topic, you must know the context, right? See, so the Supreme Court held that governors and the president cannot be bound by court fixed timelines, right, for clearing state bills, nor can court presume deemed consent if such timeline lapses. See, let's see the timeline. In April 2025, right, the Supreme Court gave a verdict, and in that verdict, it fixed a timeline. Fixed. Regarding what? For assent to state bills by the governor, or if it is reserved by the governor for the consideration of president, then even president, right? So a timeline was fixed, and what was the timeline? The timeline was 1 to 3 months, right? You must know the issue. Then what happened? That after this verdict, the President of India, right, in the month of May 2025, right, referred 14 questions, right, using Article 143, right, and referred these 40 questions to whom? To the Supreme Court, right? And in this question, the President asked that whether the Supreme Court can fix timelines for President or Governor, and so many other topics were also asked, right? So this is the issue, and in the recent judgment, the Supreme Court has clarified, and it has turned the April 2025's judgment, right? In the April 2025 judgment, it had fixed a timeline for the assent to state bills by the governor or even the president, right? But in the recent judgment, it has turned the judgment of April 2025, and it has clarified that governors and president cannot be bound by court fixed timelines for clearing state bills, right? Apart from that, it also held that nor court can presume deemed consent if such timeline lapses. So again, in this verdict of April 2025, it has also held, means the Supreme Court had also held that if such timeline lapses, it will be considered as deemed consent. Deemed consent. Deemed consent means if after the time or if the timeline lapses, right, then it will be considered as what? Deemed consent means the bill has been, or the bill has received the assent of governor or president. But now in the recent judgment, this has been turned, right, by the Supreme Court. Simple. This is the issue. But here the Supreme Court has advised, you can say it has advised the governor and president, right? It has held that the president and governor cannot engage in prolonged inaction by indefinitely withholding decisions on state bills, right? See, Article 200 does not mention the timeline, right? And when the Constitution, right, Article 200 does not mention the timeline or fixed timeline, how could the Supreme Court fix a timeline, right? And if it fix the timeline, it will be considered as violation of concept of separation of power, and separation of power is a basic feature of Indian Constitution, right? So this is the issue. So you must know, if the question comes that whether there is fixed timeline for the governor to give assent or for the president to give assent to state bill, your answer should be no. There is no fixed timeline, right? Because Article 200, it says that the governor must give his or her assent as soon as possible. No timeline is fixed, right? But in the April judgment, we have already seen what had happened. But this has been turned by the Supreme Court. So currently there is no timeline. But the Supreme Court, you can say, advised the governor or the president that they cannot sit on the bills for indefinite period. They cannot delay the bills for prolonged period, right? Now we will see the 14 questions which was referred by the President of India to the Supreme Court using Article 143. So first, already I have told you what is Article 143. Now let's read. So here, Article 143, it is power of President to consult Supreme Court, right? And clause 1 says advisory opinion on important questions, right? The President of India can seek advisory opinions from the Supreme Court of India, right? You must remember that the word consult has not been defined in the Constitution. That is another issue. It is generally considered as advice. The President can seek advice from the Supreme Court on important questions, clause 1. Second, a reference on intergovernmental disputes, clause 2, right? So this was all about Article 143, and we have already discussed the timelines, what had happened in April, in month of May, and recent judgment, right? Now, so here, two states, Kerala and Tamil Nadu, right? Objection that the reference was an appeal in disguise was rejected. So what is the meaning of appeal in disguise? See, it is a legal term, and it simply means that it prohibits the appellant from appealing any case, right, under review petition to save the time of court, right? For example, if the Supreme Court or any court has given a verdict, a judgment, right, so it can prohibit the same appellant to appeal in the same court under review petition, right? See, there is slight difference between review petition and appeal. Appeal means fresh appeal in the another court, mostly in higher judiciary, for example from district court to high court or high court to Supreme Court. But under review petition, it is filed or appealed in the same court, same case, same court. That is the difference between appeal and review petition, right? So here the review petition of Tamil Nadu and Kerala was rejected by the Supreme Court, right? And here the President's 14 questions were described as functional reference, right? Functional reference, mainly advisory opinion on important questions, right, concerning day-to-day relations between state legislature, governors, and the president, right? Now we will see all the 14 questions one by one, and the answer given by the Supreme Court is very important from your prelims and mains perspective. Now let's see the questions one by one. So first question, right, among 14 questions, the first question says, what are the constitutional options before a governor when a bill is presented to him under Article 200, right? This was asked by the President of India. Now the Supreme Court said that Article 200 of the Constitution outlines process for a governor to give assent to a bill passed by the state legislature. Simple, right? Both Article 200 and 200 are related to state bills, right? 200 says assent of governor to the state bills, and 201 reserve or consideration for the president, the governor can reserve a state bill, right? Now here under Article 200, the governor has three options. You must remember, right? Such type of questions are asked in prelims, right? So what are the three options in front of governor? So first option is to grant assent This is the first case. When a bill is sent to the governor, right? The governor can simply give his or her assent. First. Second, to reserve the bill for the president's consideration. Yes, it comes under Article 201. Article 201. The governor can reserve a bill for the consideration of the President of India. Right? And third option, to return the bill, except money bills. You must remember, money bill cannot be returned, whether it is state bill or union bill. At union level, money bill cannot be returned by the president. At state level, money bill cannot be returned by the governor. Right? Why? You can answer the comment in the comment box. Right? To the legislature with comments for reconsideration. So, under Article 200, the governor has three options. First, he or she can give his or her assent. First. Second, he or she can reserve the bill for the consideration of the president. And third, he or she can return the bill, except money bill, for reconsideration. Right? Next, crucially, the Supreme Court ruled that there is no option to withhold assent. Right? Simplicity. So here Supreme Court held that no, there is no option to withhold the bill. You have only three options: whether you can grant the assent, whether you can reserve the bill for president's consideration, or you can return the bill, but you cannot withhold the assent. Right? And the governor cannot simply refuse to sign a bill and keep it pending. Right? This was the verdict of Supreme Court regarding Article 200. Right? Now, next question. Second question, which was asked by the president. Right? So, is the governor bound by the aid and advice of the Council of Ministers when exercising option under Article 200? Right? So, you must be knowing Article 163. Very important. What is it? It simply says that there shall be a Council of Ministers headed by Chief Minister to aid and advise the governor of state. At the state level, at the union level, under Article 74. Right? Same applies at union level. But here we are discussing at state level, state bills. Right? So, it asked, the second question asked that is governor bound by the aid and advice of the Council of Ministers when exercising option under Article 200? Then Supreme Court held that no. Why? Because giving assent, here you can read the court ruled that in the specific function of granting assent to bills, the governor enjoys discretion. Right? So, granting assent to the bills, the governor enjoys discretion, and he is not bound under Article 163, which says what? The governor should function with the aid and advice of Council of Ministers headed by Chief Minister. So, 163 cannot bound, right, the governor to give his or her assent to the state bill. It is his discretion. It is his discretionary power. Right? Next, the bench, means the Supreme Court bench, reasoned that the governor's powers were not dependent on the advice. Right? It is his or her discretionary power. Since the governor was not bound by the cabinet advice, the power to return a bill for reconsideration is discretionary and would not violate the Constitution. So, simply it clarified that assent to bill under Article 200, right, or the governor is not bound by the aid and advice of Council of Ministers under Article 163. So, Article 163 cannot bound a governor to give his or her assent, right, under Article 200. Under Article 200, or the Article 200 is the discretionary power of the governor. Simple. Next, third question. Again, third question is very important. Is the exercise of constitutional discretion by the governor under Article 200 justiciable? The answer is no. Justiciable means what? The court, whether the court can review or not. Right? Whether the court can enforce it or not. So, simply the Supreme Court held that no, it is non-justiciable. Non-justiciable means it cannot be enforced by the courts. Means and not enforced means, for example, we have seen that the court cannot fix a timeline, right, for the governor or president to give his or her assent to state bills, right? Here, the Supreme Court cannot review the wisdom of a governor's decision. Simple, as I said, it cannot be reviewed, cannot be enforced by the Supreme Court. The Supreme Court ruled that prolonged, unexplained, and indefinite inaction is subject to judicial review. This is exceptional case. In general case, the Supreme Court cannot intervene. Right? It is non-justiciable. But prolonged, very long. For example, a governor is sitting on a bill for last 2 years, 3 years. Right? That is called prolonged period. Right? Unexplained reason. The governor has not explained the reason. Right? Or indefinite inaction. See? Subject to judicial review. These are exceptional cases. If a governor sits on a bill without taking any decision, the court can direct them to act. This is exceptional case, right? But in general situation, Article 200 is non-justiciable, right? Next, fourth question. So, is Article 361 an absolute bar to judicial review or in relation to the actions of a governor under Article 200? Right? Fourth question asked that whether Article 361, what is Article 361? It gives immunities, right, or protection to the president and governor. Simple, right? There are certain exceptions, right? For example, there are certain exceptions of Article 14, right to equality, right? Equality before law and equal protection of law. And one of the exception of Article 14 is Article 361, immunities or protections to governors and presidents, right? So here it's the Supreme Court held that no, Article 361 grants the president and governor personal immunity, right? Why? For the exercise of their duty, right? Stating that they are not answerable to any court for the exercise of their duties. Whatever they have performed while performing their duties, while remaining in their office, they are not answerable to any court, right? And it is their immunity or protection under Article 361. Simple. But here the Supreme Court find a way, right? Way means what? Here the Supreme Court held that while this protects the office holder, right? Though governor or president is protected under Article 361, but it does not protect the office. Does not protect the office means office of governor or president are not protected, though they are protected. See, means it has separated both governor or president and their office, right? Both two are different entity. Though governor or president are protected or they have immunity, but their office they don't have, or office does not have any immunity or protection, right? So the court can review inaction regarding the constitutional functions, right? So the court can ask the office of governor or president, right, to act on certain bills, right, to perform their functions, right? Importantly, this immunity cannot be used to shield indefinite delays. So simple, the purpose is what? That the governor or the president cannot delay the bill for prolonged period, for unlimited period, for indefinite period, right? They cannot simply sit on the bill. Thus, constitutional duties must be exercised without unreasonable delay. Simply, as I said, Article 200 says, as soon as possible, right? So 361 we have already, we know that about that. So first clause says immunity from court action, and clause 2 no criminal proceedings, right? You must be knowing about that. Next, question number 5. So here the president had asked that can timelines be imposed on the governors through judicial orders for the exercise of powers under Article 200. So here the same question was asked, which was means in April 2025, right? The Supreme Court had fixed a timeline 1 to 3 months, right? Minimum 1 month or maximum 3 months. And in the question number 5, the President had asked the Supreme Court that whether a timeline can be imposed on governors through judicial orders for the exercise of powers under Article 200. The Supreme Court said no. No timelines. We have already seen in the context, and this was the main context, that the Supreme Court cannot fix a timeline, right, for the governor or president to give assent to state bills. The Supreme Court overruled its judgment from April, right, which had set specific timelines of 1 to 3 months. Already I have told you, for a governor to act on bills, right? Simple. So simply you have to know that the court cannot fix a timeline. Simple, right? And it would be inappropriate for the judiciary to prescribe rigid deadlines, right? And again, it will be considered as violation of separation of power, which is a basic structure or basic feature of Indian Constitution. Simple. Next, sixth question. So, is the exercise of constitutional discretion by the President under Article 201 justiciable? The answer is no. Again, the exercise of power under Article 201 by the President is non-justiciable. The court cannot review, right? The court cannot enforce. Simple. Article 201 deals with the bills reserved by the governors for the President's consideration, right? Under Article 200, the governor has 3 options. First, he can give his assent. Second, he can reserve the bill for the consideration of President. Or third, he can return the bill to the state legislature, or if it is not a money bill, right? So, similar to the governor, the President's decision to the assent or withhold the assent to a state bill is not open to judicial review on its merit. The SC, the Supreme Court, open. Simple. So simply, just like 200, Article 200 and 201 is also immune from judicial review, right? Means both Article 200 and 201 are non-justiciable in nature, except in exceptional cases, right? So let's see what is Article 201. Here, it provides the process under which a state legislature passes a bill that is reserved by the governor for the President's consideration. And under this Article 201, the President has 3 options, right? So 3 options. First, give assent to the bill, that becomes a law, just like governor. Simple. This is the very simple procedure, right? If a bill is presented to the governor or President, he can give his assent, right? Simple. Second, withhold the assent, right? And here it does not become a law. Simple. And the bill generally lapses. Third, return the bill except money bill for reconsideration, right? Now, importance of Article 201. What are the importance of Article 201? See, first, it safeguards the federal structure. Second, protects judicial autonomy. And third, ensures legal uniformity. So, how it safeguards the federal structure? For example, it ensures state legislatures do not conflict with national interest or the union constitutional authority, right? Second, protects judicial autonomy. Judicial autonomy means mainly when judiciary is not intervening, right? When there is no conflict, generally it establishes judicial autonomy. For example, Article 200, 201, both are non-justiciable except in exceptional cases, right? And third, ensures legal uniformity. Legal uniformity means it helps maintain consistency in law across states on matters that carry wider national significances. Simple. Now, next question, that is 7th question. Again, just like governor, under Article 200, no timeline can be fixed. Under Article 201, same means no timeline can be fixed by the court. So the 7th question was regarding Article 200. So it says that can timeline be imposed on the President for the exercise of discretion under Article 200? The answer was no, right? So simply you have to remember that Article 200, 201, right, are non-justiciable except in exceptional cases. Second, both are or means no timelines can be fixed, whether it is governor or president, to give their assent to state bills. Simple. President cannot be bound by judicially prescribed timelines when dealing with the state bills reserved for their consideration. Right? Why? If court fixes right a timeline, it will be considered as violation of concept of separation of power, because judiciary is intervening in what? Executive, in the functions of executive, and this is not allowed under separation of power. Right? Next, eighth question. Is the president required to seek advice of the Supreme Court under Article 143 when governor reserves a bill? Right. Again, the answer is no. It is not necessary to seek advice from the Supreme Court every time. Right. It is up to the president. Right. And again, the advice tendered by the Supreme Court is non-binding on the president. Whether the president can accept the advice, or he or she can reject the advice. Simple. Right. Next. So Article 143 allows the president to consult the Supreme Court, obviously, on questions of law. The court clarified that the president is not required to seek this opinion every time a bill is reserved. Simple. Right? It is only advisory jurisdiction. Right? Not binding jurisdiction. Next, ninth question. Can courts adjudicate the consent of a bill? Again, no. It simply means that the discretion, or you can say intelligence or logic of governor or president cannot be questioned. Right? The court cannot ask the president or governor, why did you sign or give your assent to the bill, or why didn't you give your assent to the bill? Right? So here the SC rule that judicial review applies only to laws, that is enacted legislation, not bills. Right? See, in India, the Supreme Court can only review any law or statute. Right? Generally act. Right? But not bills. You have to remember the Supreme Court. Right? In India, judiciary is not allowed to review bills. Why? It is considered as legal fiction. Right? Until and unless a bill receives assent of the governor at state level, or received assent of president at union level, it does not becomes a law or act. So only when a bill becomes act, only then judicial review is allowed. Right? Bill is what? Nothing but legal fiction. Right? So courts cannot adjudicate on the validity of a bill before it becomes law. Now we will see the next question, that is 10th question. Right? So 10th question. Can the exercise of constitutional power by the president or governor be substituted under Article 142? Right? So you must be knowing about 142. What is it? It simply says that the Supreme Court can do or can pass any order, decree, to do complete justice. Right? And this article makes the Supreme Court very powerful. Right? It can do anything to ensure justice, to do complete justice. So here the Supreme Court held that no, Article 142 grants the Supreme Court power to pass any order necessary to do complete justice. Right? But the court firmly rejected the concept of deemed assent. Right? Deemed assent means, already I have said that in April 2025, right, a timeline was fixed 1 to 3 months. Right? And within this period, the governor or the president has to give assent to the state bills. Right? But in the recent judgment, this has been completely rejected. And in that judgment, it was held that if this timeline lapses, then it will be considered as deemed assent. Right? Deemed assent means the bill which is pending on the table of governor or president shall be considered as or it has received the assent of the governor or president. That is considered, that was said as deemed assent. But in the recent judgment, the Supreme Court has rejected the concept of deemed assent, right? And it said that, it held that Article 142 cannot be used to create a legal fiction. Legal fiction means what? Already bill, right? Already I have said that bill is what? Nothing but legal fiction until and unless it receives the assent of governor or president, right? It is legal fiction. And when such timelines are fixed, deemed consent or the concept of deemed consent is applied, it is considered as legal fiction. So here the Supreme Court cannot use Article 142, right? Next, 11th question. So here say, is a law made by the state legislature a law in force without the assent of governor? Obviously no, right? Until and unless, I have already said, and you must know that until and unless a bill receives the assent of governor, it is not a law, it is simply a bill, right? Next, 12th question. Again, is it mandatory for any bench of the Supreme Court to refer a matter to a larger bench under Article 145 clause 3? So what is Article 145 clause 3? See, it is related with interpretation of the Constitution. And who is the final interpreter of the Constitution? The Supreme Court. So Article 145 clause 3, it says that, mandates that cases involving substantial interpretation of the Constitution be heard by at least 5 judges, right? So as per Article 145 clause 5, right, if there is a question of interpretation of the Constitution, that case must be heard by a bench of 5 judges, at least 5 judges. Simple. If there is any question, right, even any term that is related, that is being interpreted by the Supreme Court, right, it must be heard by a bench of 5 judges. Under which article? Article 145 clause 3, right? So the court stated this query was irrelevant to the functional nature of the reference regarding legislative assent. Simple. Now last 2 questions. 13th question. Is the power of Supreme Court under Article 142 to do complete justice, right, limited to procedural law, or does it extend to issuing directions which are contrary or inconsistent with the existing substantive or procedural provisions of the Constitution or any law in force? Simple. So here the court found this question too broad to answer definitely, but clarified that as per its response to the question number 10, Article 142 cannot be used to override substantive constitutional provisions like requirement or assent. So simply we have seen question number 10, right, that Article 142 cannot be used, right, by the Supreme Court what to do complete justice. Means here in case of Article 200 or 201, Supreme Court cannot use Article 142. Simple. Means question number 10 and question number 13, right, both are correlated. Last question. Here, does the constitutional bar or restrict any other jurisdiction of the Supreme Court to resolve dispute between union and states except under Article 131, right? So what is 131? It is called original jurisdiction of the Supreme Court regarding disputes between center and states, or between 2 states or more than 2 states. That is the original jurisdiction of Supreme Court. But here the important answer is the court declined to answer this question, right? When the court declined to answer, no need to discuss this question, right? So simply you have to remember that under Article 143, right, if the question arises between the conflict, generally conflict arises when a state bill is reserved by the governor for the consideration of president, and it creates the tussle, the conflict between center and states, right? Then here Article 143 can be used or not. Here the answer was not given, or it was not clarified by the Supreme Court.